who in 2017 somewhere. I'm okay University campus. In about 7 years, and then the first time and run the first time I make a comment on it, and I repeat one in Sheffield because it was on a different platform. But Ato Forson case, my man starting to say, I'm not a lawyer. Me law that. But I've listened to many lawyers.
Right.
I've had the opportunity to listen to Kwaku Ansan Asare, former director of Ghana Law School, lawyer Bobby Banson, Justice Ramsey, my métier attorney general and kasa métier tia the deputy no métier Edwigi Tamaklo which is Ato Forson counsel métier the Leonard attorney general AG ope unifa ba kon be se Michiana Ghana pa Dr. Dominic Ayeni former attorney general very fantastic gentleman me pena sempa métier omu nyina. So what I'm coming to present on Ato Forson no, I'm not a lawyer but it's a summary of analysis of lawyers. Métier me pese me ne ma hwefo hwe a day in appeals court no say Ato Forson acquitted and discharged.
Right.
The case acquitted nko in discharge one is a case you betimi abaso by a case acquitted and discharged na so ko kan kron
so ko die the sabia na so ya de ko
yes o ya de ko ya say you but we dey nka say kofie na doctor bebe fia be hwe and only acquitted. The doctor Samber will help you. We are acquitted and discharged. There's a doctor Mefie bio. Okay. This is the Leonard Attorney General and Ghana no pay jurisprudence.
Right.
He is the leader of the bar. There's the lawyer Sifuni na.
Aban
lawyer penny.
Right.
Answer na aban bedi jume bia no kra na so gina dwenkyere.
Okay.
It's in the position no occupy a big position. The entire me explain for the first time me follow politics. Ghana Bar Association akabibi me baso later.
Right.
This is Godfrey Japa. Big C company na no be my ambulance worth 2.37 million euros.
Richard Japa.
Richard Japa no. On na no your agent.
Okay.
What I said say akokwa wo Dubai ya wo ton ambulance. Me na me te Ghana me ye wo contract amount me ye wo agent.
Okay.
What I say. When say be a company si omo bo omo tonton me no man fa mabu no mu guadum no mu ye omo your agent.
Okay.
Tenye company no. But omo ton company ho ne no mo bo company no ho dawuro. What I say. Anna the last person no the last person cry. Na ye case Ato Forson. Minority leader currently then deputy finance minister and the boss and the Setekwe. The reason why I'm boss Setekwe din is important for the ruling.
Definitely.
Now the fourth person on your friend Sylvester Animana, now your chief director of Ministry of Health.
Yeah.
Case na Koso High Court, judge no state na started prosecuting the case any other. Owi you know, and a trial judge and they say Obronika be prime facie. The attorney say, Subona me debo akokwa no. Me dwen ho a asa subon ejina. Subo be na ban edible case Ato Forson. Say financial loss to the state. Na financial loss on niam miensa na wo jina so ni. Ye frɛ bibi LC. Ye attorney say wo mu obi to me every bank of Ghana say won fa de bi mre Ghana na the buy ye betua ne ka. One. So ye kase wa cause financial loss to the state na ye say at the time honorable Ato Forson sign sa LC na woni mu say ambulance na sembeba ho one agokwa atase.
Okay.
Two LC na was sign ye no e kire say ye ntua ka na letter of credit no doesn't mean say the issue of the letter of credit doesn't mean guarantee of payment.
Okay.
Say me ko bank akwa kire bank ni say oh fa won fa we niam amra ne be betua ma no sa ye betua ma no ye say ye betua nkasa na anasa there are certain conditions that have to be met to ensure payment.
Okay.
How does the guarantee become payment? That's the second thing.
Guarantee.
Yes.
It is say memfa ne say wo ko bank akwaje besia.
Yes.
Ne yesi pe guarantor.
Yes.
It will guarantor assign.
Yes.
Say ampower jitum si yem first can ma.
Yes.
Right?
Yes.
It has to say condition bank ni wo sika dodo na wo pe na na so wo mu nie no.
Yes.
Anase ye de be ma wo no. Eno nso wo.
Eno
ntre say ye sign wie ye sika na ka won.
Yes.
Right.
And the third leg ne say oh ye deputy finance minister no.
Okay.
All sign sa LC no letter of credit no. Na ne boss Setekwe enim hu bia na.
Right. Okay.
So these are the three elements. Again, me a lawyer.
Definitely.
I'm just summing up the views of about 10 lawyers.
Right.
Me now before the Krebi Kawo more laws, MK Gaddafi, Kofi Opare Hegan. Omunyina views I'm summing up.
Okay.
So this is it. Etiye akoso trial court judge ni jitu mu say there be there's a prima facie case. Nyina so bi wo ho attorney general establish.
Okay.
Enti in the view of the high court judge no Ato Forson has caused financial loss to the state.
Okay.
And the state no producing evidence we no. The trial judge was of the view say Ato Forson should open his defense.
Justice say one.
Yes.
All right.
If you say why and I have forgotten the name.
Yeah.
Because say a criminal proceeding is about the liberty.
Okay.
Of Kesu Ato Forson and Richard Japan. And to say obi abon so bo a. Me so me ma kwan say won so bet ban o case. The kan wo de na ye ntie na ye wi ye boa.
Yeah.
Eho ana Ato Forson lawyers said there be. They will go to the appeals court.
Right.
To review that decision no. Say omu de omu nyentum say establish any prima facie evidence. Na evidence na Attorney General ni the state e de aba so far no. And charge any charge no mo de bo ne client no. Enko. Okay. Akwakwa say it's one of the court appeals court. No mo court appeals court then na aba. Three judges at trance no. One, ye fra ba ko Alex Opoku Echampon.
Right.
Unza me surname ye Champon ba me use. That's my surname, yes.
Right.
You just say it's Champon.
Okay.
Then the next judge I Justice Bright Mensa.
Okay.
Then the judge not through the lead judgment. I find the Justice Kweku Tewia Akabuafo. So these are the three judges. Nti NSA say ko appeals court and most Supreme Court. You pay odd numbers. Say nyan koye say 44. Na sam ne say akotwe there bi. Say you pay odd number. You can odd number 3, 5, 7, na 9. Aha, and you find odd numbers. Say you bedu ebenya judgment na bi anya majority and minority. They say you mun koche pepe sa.
Definitely.
Na judges 3 no ruling no so 126. Me take 4 days na kan ye.
Wow.
Two obi o lawyer ni a.
Ma men kai tie for say live on Facebook. Enti wo mo person join here no your project ruling no bibia e wa ha no. Mo betimi a join on Facebook in Sha 104.5.
Te minim so betimi zoom no Facebook for na kaba me kan ma wo. But okay ruling na 126. Ja kwakwa se na me kan wo obi obusuam no lawyer ni a respect no. And the 4 days.
A lawyer for sunya di.
And e kan ye Thursday anumre na me kan wie. Na judge baako ono na ma the minority decision.
Yeah.
Who say after the appeals court met no. Case Ato Forson and Richard Jakwa was what? Acquitted and discharged.
Wow.
A 2-1 decision. Mama started minority decision. Na me you obi ade 2-2. Ana me dey bon komo no. Yen koso.
Okay.
And so ba say say this is the certified true copy.
Yeah.
Of the judgment 126 means minimum 126 na say yempon.
Yeah.
But okade bi Justice Alex Opoku Echampon no na the minority judge no na okojina Attorney General afa men kan sa and the two na kan Justice Bright Mensa and the Justice Akabuafo okojina Richard Jakwa any Ato Forson afa then Justice Alex Opoku Echampon ko say Otro ne brofo na no mamen kan crab say in analyzing the text of section 14 of the act and commentary thereon on the issue of the knowledge of the parties in the case, especially the matter of whether the LCs were issued with or without authorization, the facts are better known by the first accused or appellant. First appellant is Ato Forson, right. And it's particularly within his knowledge. The desirable results in terms of public policy will be to have him lead evidence on it.
Okay.
According to Justice Alex Mensa, or say, a deputy finance minister, Seba say audio authorization and an knowledge on LCs, letter of credit, SO1. It's only trial judge, you know, Yanko so say, I therefore agree with the counsel of the respondents. I have no respondents now by Attorney General.
Yeah.
Because the appellants are Ato Forson and Richard Jakwa.
Right.
That the trial judge did not err on the basis of the authority in Judge Onosati case. It is in order to ask A1, that is Appellant 1, Ato Forson, to provide his assertion that he was authorized by the Minister of Finance to issue Exhibit A and B2. Cha ruling way.
Yeah.
Ade ba kwa na ye material pa edin a ukọ rule na ewo mu pa e di mienu. Setekwe then finance minister and Kwekwa Jimame no. According to judge we no say in criminal matters there you the state must produce evidence and accuse you.
Definitely.
Then you must defend yourself. Judge we say na to force counsel say edu baby na kwakwa say they feel Ato Forson ruling na case na Attorney General. Not Ato Forson na man evidence of jail no. Charge and say Ato Forson and they say provide evidence say. The Minister of Finance then say take no. Let the na o issue no ni hubi. What I say?
Yeah.
In criminal matters no. Attorney General mom na can say the letter say Finance Minister ni mu bibia say take ni mu bibia. But the judge is saying that Ato Forson should rather provide that evidence. What I say?
Who alleges must prove.
Yes, that's the natural law. But citing case be and or the
okay.
And Osha, really ruling now. Almost all the cases are just as the citing, the same.
Okay.
Whether dissenting or agreeing, but how they interpret it is different.
Okay.
So according to Justice Alex Opoku Champion, on the dutum say, Ato Forson and Becca and I say take when him let the new business evidence, say Ato Forson in the deba and Attorney General.
Yeah.
One. Yanko two na so. Again, Justice Opoku Champion na American.
Okay.
Or say, as remarked rightly by the trial judge. From the evidence on record and addressed by this. This showed they were defects in the ambulance when they were delivered. They were not fit for purpose. As observed rightly by the trial judge, the issue of the defects in the vehicles was not controverted in cross-examination, and it's a tacit admission of the fact. According to Judge Wayne. Ambulance na buy an answer that adwuma na cross examination ni nkomo ne kire guilty be a Ato Forson and Richard Akwetrim.
Yeah.
So, Justice Alex Opoku Champion, most of the ruling was based on cross examination, was based on evidence that Ato Forson moment farmer.
Yeah.
And that was why he dissented. Now because of time, yanko Justice Brightman san.
Okay.
Oko Justice Brightman san. Ni ruling ni nyina no. Na ye based on say. O say nipa no authorization no. Wanje authorization from Setekwe.
Yeah.
But akokwa ugugu says here it will pop up. Setekwe has on many occasions said that he knew about the letters of credit. This is public knowledge. It is Attorney General Frena. It is also strategy.
Yeah.
Or Frena understand. Or because the minimum letter now my deputy Troy. That will be injurious to the case of the Attorney General.
Right.
And say you only share someone friend.
Yeah. It's true.
And to shall be a justice judgment's account. Or say my main kind at the Amawa. Or say it is instructive to observe that Honorable Kwekwajiba Menu is evidence to the trial court on date we admitted that the appellant copied Honorable Setekwe of each letters he wrote in connection with the request for the establishment of the LC. So Setekwe is a material witness.
Yeah.
Akokwa, you're charging me say I'm causing financial loss to the state. There are three reasons. Letter of credit doesn't mean payment. One.
Yeah.
Did I have authorization? Would I have known ambulance there by the papa? Justice Bradman sounds a question with Attorney General and say. Letter and when I Justice Bradman an account. The health minister or succeed a buying I free sono. I'll expect Befiano. I Kwekwajiba Menu. Kwekwajiba Menu accountant. Only from the letters of credit public accounts committee da. Or say letter no crack Ato Forson Trobian or copy Setekwe.
Okay.
So all charges Ato Forson say well no authorization. It's a bit checked.
So that time 2022 no.
Yes.
The minister then.
Yes.
Na ono so ewo aban we mu Attorney General wo mu bi no.
Yes.
Confirmed say.
Yes.
Let's say
yes, because handing over note.
Yeah.
2016, about for 2016. In the handing over note, he says that honorable Kwekwajiba Menu evidence was on the 21st of July 2022. Also letters obey who you know. Letter be around by this case, you know. The finance minister then, though his deputy was writing the letter, was copied.
So Setekwe should have been involved. Can say I didn't case, you know, because
but America says Setekwe can manipulate, including Joy. Say he knew about the letters. So the Attorney General is not calling him because it will not ignore to the benefit of his case.
Then you're interested in saying. That's the big question.
That one is for the court to decide. Now Shadi bi was say Shadi, from these pieces of evidence, it can safely be inferred that the minister was aware and approved the steps the appellant took. Appellant ni Ato Forson.
Yeah.
So according to Justice Bryce Mensah, or say, you copy letter ma second answer the letter brain. Me you don't say to don't throw directly to me.
Yeah.
Me chief operating officer.
Yeah.
Or better to Jimmy Yagla. General manager of Kumasi unit. No, I copy me programs manager because you just said to me, should be a first line manager. DJ Apuzo.
Yeah.
So Apuzo will be copied, Jimmy will be copied, I will be copied. And if Jimmy is copied, Jimmy cannot feign ignorance. If Apuzo is copied, Apuzo cannot feign ignorance. So according to the wisdom of Justice Bryce Mensah, if a letter is written and you are copied, it means that you have express knowledge of that letter.
And already Ajima Menu has confirmed that.
Yes.
Se tepe.
And you see, Nyama yesterday say Ajima Menu MPP ni.
That is yeah me.
Justice Bryce say, in the circumstances, I disagree with the findings of the lower court, the high court, that the appellant had the duty to prove the affirmative that he exercised due course and authorization. The natural young colloquial say he who alleges must prove. Not trial judge and say, Ato Forson mom them for evidence so on your authorization. Justice Bryce Mensah no come address you listed there be and yes and it it is rather the state that must prove he didn't have authorization. What I say? I say, and I say, having regard to the above, then I do uphold the submission of the learned counsel for the first appellant. Next one, Ato Forson lawyers now answer crown. Justice Bryce Mensah Ekadibi. And a very, 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 very important. Or say, my main came out first line. However, having regard to the overwhelming evidence that the Ministry of Health, for no apparent reason, refused or neglected to do pre-shipping inspection and visit under Exhibit 2, Big C, Papa. And in Yabofo Kenya say, I don't know to force the ambulance here defective. Me establish 3 grounds, man.
Right.
That's LC means guarantee. Or issue LC no ni ambulance in your papa. 3 on your authorization. Just as the man said, Busa say, every day na to force him say ambulance defective because I didn't even do report no. While the government of Ghana has not taken delivery of them from the Tema port, the lower court fell into serious error when it called upon the appellant to open his defense. It is a clear travesty of justice for the appellant to be called upon to answer that charge. Or say, charge that when they bought the ambulance is defective, and then yes, Ato Forson or say a travesty of justice. Now say, over say travesty, over say, one fucking case. So only about Nibia because only Juma health ministry. And to say you will be crank so answer to the defectiveness of the ambulance. And say you will be our health ministry, not finance ministry.
Definitely.
You know, or say in the final analysis, it is my respectful opinion that there has been no evidence to prove an essential element in the crime, or that evidence was so manifestly unreliable that no reasonable. I don't know where's in your strong mommy.
From the reliable, the preceding paragraph, no, it was very
So make was say. In the final analysis, it is my respectful opinion that there has been no evidence to prove an essential element in the crime, or that evidence was so manifestly unreliable that no reasonable tribunal minded to do justice in the matter could safely convict upon it. I do therefore allow the appeal on count 5 in favor of the appellant. Or say, Judge BNO and our court to BNO per se. Nitrimu fine or the boasama obey evidence or do the bois person for.
Very serious
for a judge to say that. No, already on travesty of justice.
No reasonable tribunal minded
that to do justice. And again, now I use to travesty of justice.
Wow.
And to Sanka say tribunal minded to do justice. Next, what justice we here.
Okay.
And all kinds of evidence now Attorney General providing ha. Some evidence no jina so the Ato Forson and everything that fa enye. This is Justice Bright Mensah. If Mama two Justice, Mama Justice Alex Opoku Champo, and Mama Justice Bright Mensah.
Next one we go for the appellant.
Yes, Yanko no true leading.
Yeah, okay.
Justice, Justice Kweku Teria Akabuafo.
Okay.
Or say, Mama Mount Ayibiwa. Yes. Who's a criminal law? My catcher say, he who alleges must prove.
Definitely.
Or say, a strict liability in criminal law is a liability for which mensura does have to be proved. Mensura, they be okukuka intent. You have to prove the intent.
Yeah.
Or say, the liability is said to be strict because the defendant or accused will be convicted even though he was genuinely ignorant or reckless of his actions. It's about the liberties of people.
Right.
And to show on the response, he was also arguing that to prove that Ato Forson knew or didn't know, it must come from the state.
Definitely.
Not Ato Forson. On the matters of whether LCB's payment, are proving that the court says that Setekwe wasn't called by the Attorney General, which to them wasn't okay. But Setekwe outside court has said that he authorized
and Ajima Menu
has confirmed it.
Has confirmed.
On the matter, say, Ato Forson should have known the ambulances were defective. No, Justice Mensah answered that and said that he couldn't have known. Rather, officials of the health ministry should have known. It's my established here. The third one was whether LC means guarantee. And another health ministry was because of health and money issues. No, it's health
management,
health management, economical. And I know I have public accounts committee chair. It's your boss and what's here. Justice Akabuafo, say. You feel Kwajima menu. Oh, but can say, oh, no, let us a woman. Ato Forson, a boss, a tepamania, or copeno. Or some candy will say. Mr. Ajima Menu also told the court that if an LC has not been established, payments cannot be authorized. He also said that even though the letter requesting for LC is a primary document, the Bank of Ghana will not be able to establish an LC with the letter only. This is a health minister who inherited from the NDC health ministry and also an accountant of strong repute, saying that letter only or say will not be able to establish an LC with the letter only. And on a primary document in here,
there should be other things involved and sana. Right.
See, interestingly, despite the very clear and unequivocal answers about that the LC was not a payment but a guarantee. Paragraph 71, very instructive. That it is a clear third leg number.
Definitely.
Interestingly, despite the very clear and unequivocal answer above that the LC was not a payment but a guarantee, Mr. Ajima Menu later gave a different answer. On August 30, 2020, it was the first time I called court on
July
21st July 2022. Later, according to Justice Akabuafo, any evidence I court on August 30, 2022, when he said that per the terms of the contract, payment should be done by the LC. Therefore, a request for the LC to be established meant requesting for payment to be made.
So a month later.
No. First, no can say LC any guarantee, any payment, guarantee. Now, Sakwani betu your conditions be a meeting. After 1 month, no bar court in a go because there be contract and there not LC chese.
So he's giving conflicting evidence.
Now, you say, my loss, due to the inconsistencies in the record of the evidence of Mr. Ajima, I consider his later evidence an unreliable and is later as unreliable and place no weight on it. According to Justice Akabuafo, or say, Kwajima Menu evidence no the bar August and on into unreliable. On Fabubian to wait to be in Nassau.
Right.
Why would just say that? Because of the inconsistency.
Right.
Or say, be that as it may, in my thinking, does the above evidence support the preposition that by authorizing the letter of credit, as opposed to on August 17, 2014, August 12, 2014, the appellant caused the payment of the ambulance to be made as a result, called the financial of 2.37 million euros? Debbie. Also no answer. So this is the wisdom of justice kwekutewia akaboafo.
Right.
Now owie you know. Last the concluding way, not true. So say, based on the evidence heard, in my view, no reasonable tribunal can safely convict on it. And to check justice na ekojina Ato Forson and Attorney General Fana. Omunya yusu words be reasonable, fair, travesty of justice. And these words for me are very, 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 very instructive. Because I'm not repeating the same thing there. Based on the evidence heard, in my view, no reasonable tribunal can safely convict on it. Also, in my respected opinion, the evidence proffered by the prosecution against the third appellant cannot even be said to be open to two likely explanations, but only one.
Cardinal West said, no reasonable tribunal has been repeated again, right?
Yes.
By the two judges.
Yes, and because they are standing on the evidence provided.
Okay.
To amu nyomo Kenyan say so far no, Attorney General nkura obo court nyina no. Court be no offer, e so otimi dem obi ko prison, there be.
Right.
Omudin said the Attorney General has not done enough to prove his case. Sano muka. Such charge near the about case Ato Forson. And me with Japan. Based on the ruling of the appeals court, I mean what can we ruling,
oh yeah.
The two majority judges come to a conclusion say evidence ni more ha.
Untimi nyina so.
Owie no and I say let's conclude in their place and order upholding the submission of blah 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 blah. Therefore, both the first and third appellants in respect of those three counts in the charge sheet are issued. Subsequently, both appellants are hereby acquitted and discharged.
Wow.
And the Attorney General sometimes we so strong. We don't have any dealings. Ghana Bar Association criticize him.
Yeah.
Say for him to describe the ruling of the appeals court as perverse.
Yeah.
Perverse results of mashada munim papa na ba munye.
Mashada
na mo yes no ma criticize on. May I think that he's becoming a bit emotional.
Yeah.
That's my respected view. Radio, so sometimes some of the words he uses no, I saw to the book akra.
Yeah.
Because
and he's the same person who was calling, say, politicians in respect to the judges.
Yes, because I mean, other lawyer been there fine, but for the Attorney General, no. And again, my lawyer is not educating me, says, plea bargain numbers of 1.5 million euros.
Yeah.
And said, Dan Cosa, there's a way be a bit when you scan it back. Media Macan, say, go for a damema, whether we be Kojil, be mean interest room.
See, can't you hear?
May Obibo Kubas will be a boy a chrono, supposedly, allegedly.
Yeah.
2.37 million or say ambulance and from my dear mammy back. Now, me, my 1.5 next a Ghana Babo just around 800 million. Me to me, magic scan.
Yeah. Yeah.
Tell no, I'm interested upon best music scan actually and almost so far and shreying. Per lawyers and me, lawyer.
Okay.
Explanation numbers so fair. There are other processes be a bit fast with the Jessica.
Okay.
Attorney General MFA Pabusano. Then a rule in the buy and I said, then I want you to say this senior party to the case. Company no agent na party but company can senior party to the case. That's his explanation for about 1.5 million euros out of 2.37 million euros. The media me Attorney General meje masa prosecute case no. So we be ko jail no and fam me to me no me ni interest via wo media nza me church say but me interest say Ghana nya 1.5 million euros na be nyama bebre.
Oh definitely.
And see this is the summary of the judgment. Now Attorney General indicates to the Supreme Court, which is the apex court, the last appellant court of our land. Now, we call to challenge the decision of the appeals court.
Court.
It's the right.
Eugene say to